no need to raise your hand. Okay, just tell me. Thank you. Second last question. For the first part, I think I will spend around 20 minutes to cover the remaining part of chapter 9. That's about legal profession. So it's the part on I think some privilege against lawyer. Also we'll cover, and then we'll cover the topic of legal aid. Following job. Okay. For the next lesson, we'll cover a very short chapter which is called alternative dispute resolution, ADR. Mainly include mediation and also arbitration. These are the two major forms of ADR. And then in the second part, I will do the revision. Okay? And also we'll go through the assignment again. If you have any question, you may send me email. And now we go to the last part of chapter 9. So in the last lesson, we have already covered the disciplinary action. For disciplinary action, we have two professional body, the Law Society and also the Bar Association. Both of them have some professional code or code of conduct. If there's anything wrong, there will be disciplinary proceeding. 紀律聆訊. Disciplinary proceeding are in addition or as an alternative to legal proceeding. For example, if a lawyer is guilty of deception, so he will be usually he will be prosecuted first, and then if he was found guilty, then there will be disciplinary proceeding. Usually the disciplinary proceeding will be after the criminal prosecution. But some some professional conduct may not amount to criminal offense. Okay, for example, some bad behavior is only it's only professional misconduct, but it will not amount to legal proceeding or criminal prosecution. There will only be disciplinary proceeding, but not any legal action. Professional misconduct means any failure to comply with the standard of professional conduct. There will, if there are complaint against the solicitor, the complaint will be made to the Law Society. The Law Society, I think they have their own investigation officer. After the investigation, the case will be referred to the Solicitor Disciplinary Tribunal. So it's a tribunal established under Section 9 of the LPO. So there are some power under the tribunal. The disciplinary power of the two tribunals are essentially the same, more or less the same. And also include striking the name of the solicitor or barrister off the roll. It means something permanent. So the name of the solicitor or barrister will be removed from the list, forever. Suspension from practice usually is for a certain period of time, maybe 1 year, 2 years, or 3 years, and also payment of sums of money or censure. Means that he will be he's censored by the society. Any other order usually I think mainly is order as to cause. So order as to cause. Of course, the member, the solicitor or the barrister, they can always appeal to the Court of Appeal. The law was changed in 2005 so that there can be an appeal from the Court of Appeal and then to the Court of Final Appeal. Previously, the appeal would only go to the Court of Appeal, but now it could go further to the Court of Final Appeal. Now we go to the last part. So it's called immunity. Immunity, okay? Immunity means some kind of exemption. When you study law, you find some people will enjoy immunity or exemption. Of course, in contract law we have exemption clause. But basically, when you study tort law in module 3, you know some people will enjoy immunity. Basically, it's the judges or juror or legislative counselor or a witness in a court case. In this topic, we will cover the immunity from suit which is enjoyed by the barrister. You know that later on you know barrister or advocate they will enjoy immunity. There are pros and cons. We have so many arguments against and also for the immunity, and also we have to know the current legal position. So first of all, you have to know the term advocate. Advocate means a lawyer, say appearing in the court. He may be a solicitor or a barrister, right? So because for solicitor, they have the right of audience in the law court, and also we have the solicitor advocate. So they can have right of audience in the say in the high court, right? So for those people, they have for a very long time been immune from action in negligence for the way they conduct a case in court. So it's the law was established by the case Wando and Woolsey in the year 1969. It was something relating to immunity from suit, right? Suit means legal action. One important effect of the immunity is that it prevents client from being fully protected against misconduct by lawyer in advocacy. So it means that even though the lawyer is negligent, so if we have the immunity, does it mean that the client can never sue the lawyer? Of course, it's something not so desirable. This makes lawyer advocate a privileged class of professional. So for the barrister, they have enjoyed the immunity for a very long time. But of course, it is always under criticism. So many people criticize the immunity which is enjoyed by the barrister. So we have to know how far is this justified. So for those who are for immunity, they have to justify why the lawyer can enjoy the immunity. So there are the argument. So first of all, people argue that advocate owe a duty to the court as well as to the client. It means that for the lawyer, they have to follow the rules laid down by the court, because they cannot do so many things. They cannot do something improper, so they cannot say just fight for the interests of the client. So they have to follow a lot of rules, so prescribed by the court. So it's also the reason why sometimes they cannot win the case. Sometimes why they have to lose the case, because they have to follow the rules laid down by the court. The second one is the cab rank. Cab rank in fact means taxi. Some people say that barrister is just like a taxi driver. So if you are a taxi driver, if there's a passenger, what can you do? If the passenger said, "Oh, I want to go to Yuen Long," so even though you don't want to Yuen Long, you still have to take the passenger to Yuen Long, because you are duty bound to do so. Barrister is also the same. As long as barrister is disengaged. Disengaged means that he has low engagement. And also a proper fee is tendered to him. He's bound to accept instruction. What does it mean? It means that he cannot refuse any instruction from the client. Okay? For example, if someone who's involved in a murder case instruct him, he still have to represent that client, even though there are very strong evidence against the client. The client so was caught red-handed in the scene of the murder. The client so killed so many people, so many students, so many girls, etc. It's a very terrible case. Still, he cannot refuse the instruction. He still have to represent someone who is notorious. Okay? Even though everyone in the society know that he has actually committed the crime, the barrister still have to represent him. The barrister still have to say no, argue for him. Okay, still have to fight for him. And also, some people argue that it is undesirable to have re-litigation. What's meant by re-litigation? Because if the barrister is representing a client in a criminal case, if the client so was found guilty, the client want to sue the barrister for negligence, so there will be another litigation. So we call it re-litigation. So because when the client sue the barrister for negligence, is another litigation. So we call it re-litigation. So it's something highly undesirable. It's highly undesirable, so we call it undesirability of relitigating the original action in the action between an advocate and the client. Because when the advocate is being sued by the client, so it's another litigation. So number 4 is the part of the immunity from civil liability, which attached to all persons participating in court proceedings, such as witnesses and judges. Some people, for example, witness. Usually, witness will not be sued for negligence because some witness, they cannot recall what had happened very clearly. So there may be some mistake made by them. They will give something wrong, some wrong information, etc., etc. But witness can enjoy the immunity. Otherwise, no one is willing to be witness. Okay. If the witness know that he may be sued for negligence, so you cannot recall the case, the fact very well, he may be sued, so he is unwilling to be a witness. Okay. So judges is also saying, nowadays so many people criticize the judge. So in our system, you can only appeal if you think that the judge is making a wrong decision. But the judge will not be held liable when he make a wrong decision. Right? Other professional, such as, but of course, immunity is now being challenged. So many people challenge the immunity. So many people think that immunity should not continue. Okay? Other professionals, such as doctor, do not have immunity from suit. In fact, negligence or professional negligence nowadays is very, very common. Nearly all the professional can be sued, okay? Including doctor, architect, accountant, solicitor. Okay? So all of them can be sued. So you can find so many professional negligence cases in the newspaper. Of course, the professional will try to settle with the client, so the case will not be open to the public. But sometimes they cannot settle with each other. So it's the reason why the client will sue the professional, and also the case will be reported in the newspaper. There are other means exist to prevent unjustified attack against lawyers, such as the power of court to strike out the action as an abuse of process of the court. People that if someone from time to time when we are reading newspaper, so we know that someone is going to sue the other person, maybe the government or the hospital authority or the SFC or the bank. But if the case does not have any justifiable ground, so the court can say that it has no reasonable ground, it is close to no reasonable cause of action. So it will be struck out. Okay? The court can strike out the action. Strike out the action means that the court can simply discontinue the action because it's an abuse of process of the court. 濫用司法程序 okay? So in civil case, it's also possible. Don't think, of course, some people always want to sue other people. Sometimes they do not consult the lawyer. They do not know whether they have a reasonable ground to take the case. If the case is totally groundless, so it will be struck out because it's an abuse of process of the court. But the law has changed. We always mention. English law, common law is always developing. I don't expect the law is the same forever. So in this case, House of Law in England has abolished the immunity, partly on the basis of the above reason, according to a case called Arthur J.S. Hall and Company versus Simon. So it is a 2002 case. But the legal position in Hong Kong is not quite certain. Why? Because so when you study the doctrine of precedent for House of Law case, in the past they were highly persuasive. So in practice, they are binding. They were binding on all the courts of Hong Kong. Okay? So the House of Law case would be binding on CA, say High Court and also District Court and all other courts in Hong Kong before 1997. But of course, House of Law case nowadays may be less and less persuasive. It should be less and less important. The Hong Kong have not been bound to follow English precedent since the handover. However, they continue to have considerable weight. So if the same case, same situation happen, of course the court will consider very carefully the judgment of Arthur J.S. Hall. Even though England has already changed the law in the year of 2002, but the legal position in Hong Kong may not be too clear. Okay? So in a case called HKSAR and Hong Chen in the year 2006, the Chief Justice at that time it should be Justice Andrew Lee. He cited the decision in the Arthur Hall case to illustrate that when it overruled Wando and Woolsey, it did not mean that the earlier case had been wrongly decided. When a case is not followed, it does not mean it was wrongly made. It sometimes only means that the society has changed, the legal position, the legal principles should not be, should not remain. Okay, so we have to develop the law, we have to change the law to suit the need of the current situation. So he said, rather the question was once we consider over 3 decades later in the light of changes in the law of litigation, the functioning of the legal profession, the administration of justice, and also public perception. These are the factors which will affect the development of the law. So Hong Kong are not bound by the House of Lords decision after 1999. The Hong Kong court have to be persuaded by the reasoning in Hall. Okay, so the legal principle in the case of J.S. Hall, it will not automatically be followed in Hong Kong. So the legal position is still not too certain. Chief Justice made claim in Hong Chen that he was not expressing any view on the question whether the common law in Hong Kong on the question of advocate immunity should be developed along the same line as in England. But we have to realize that the judiciary in Hong Kong is even more conservative than that in England. You'll find so many things have already changed in England, but not yet changed in Hong Kong. There are so many reasons. One of the reasons is that we are quite conservative, or you can say that Hong Kong people are lazy in the change. I think we are very hardworking in so many things. But regarding change, regarding the reform, we don't have a very strong incentive. I can say that many Hong Kong people, they don't want to change. Okay? There are so many reasons. On the one hand, so people are older and older. So you say that. So in the street, in MTL, you can find so many middle-aged people, so many retirees, and also so many people, they are so afraid of change. Because they are so afraid of the possible influence from the Chinese government. So many people, they prefer not to change the system so that they can safeguard our current legal system and also our rule of law. So now please do filling in the blank. So I give you 2 minutes time. So please do all the questions before we proceed to chapter 10. Okay, I think we can now go through the answer very quickly. For the first question, so the two category of legal work. So we classify legal work into two category. The first one is advice and assistance out of court. It's called non-contentious. For example, divorce or say agreement, tenancy agreement, listing, IPO. Usually they are non-contentious. The other one is representation in court. So it's called contentious. So it means either is relating to litigation or non-litigation. Number two, in Hong Kong, litigant has two choices. Either being a litigant in person, LIP. So it's a usual term we use nowadays. LIP, litigant in person. 自行代表. It means that he's not represented by any lawyer. He represents himself or in person. Just like Mr. Yun said he was in person. He was not represented by any lawyer, or he can retain a lawyer to represent him. I don't think a court of first instance of the High Court and above only barrister and solicitor advocate have the right of audit. For solicitor, ordinary solicitor, they have low right of audit. Number four, barrister are specialists in advocacy and also legal advice. From time to time, the lawyer, even the solicitor, they will seek legal advice from the barrister. Even the law society, even the Hong Kong government will seek legal advice, or sometimes we call it counsel opinion. Sometimes they will seek advice from a lawyer in England. Okay, there, of course, there's so many reasons. Sometimes they simply want the advice. Sometimes they also want someone to support the standpoint. For example, if the government has made a decision, so sometimes the government will seek counsel advice in England so as to support the standpoint of the government. Solicitors tend to do more of the paperwork. For example, preparing, document, agreement, contract, etc. It's the usual job done by solicitor. We think that establish a contractual relationship. So for the solicitor and the client, they have already entered into a contract. So we call it a contractual relationship. The professional term is called retainer. The line of retainer. Number six, general duty of solicitor include to carry out client's instruction and the matter to which the retainer relay by all proper means. He cannot use improper means. Everything must be proper. Also to maintain confidentiality. One of the major sources of ethical rule in Hong Kong is the legal practitioner order. It's the LPO. Advocates have for a very long time been immune from action in negligence for the way they conduct a case in court. Of course, the reason why the legal position is unclear because we have no such action. No one have tried to sue the barrister. So of course, it's not easy. People that sometimes advocacy is an art. Sometimes we don't have very concrete standard to measure whether a solicitor is negligent or not negligent. I think for solicitor it will be easier, but for barrister it will be more difficult. Number nine, one of the justifications for immunity is the undesirability of relitigating the original action. It means that there will be another legal action for the same matter. Okay, now I think we have already finished chapter 9. Usually in examination there will be a question in chapter 9 about the possible question may be on duties of solicitor, the ground to decline a retainer, the fusion, right of audience of the solicitor and barrister. There are so many possible questions in this chapter. And now we go to another chapter. That's chapter 10. Chapter 10. Chapter 10 is a very say is something very systematic, and also we have a lot of information from the website of the legal aid department. So chapter 10 is about legal aid. But please note that legal aid, we have two major sources of legal aid in Hong Kong. On the one hand, we have the legal aid department, and also we have the duty lawyer service. Legal aid department, of course, of course, is the bigger one when compared with the duty lawyer service duty lawyer service 當值律師服務later on I will tell you so what's meant by the duty lawyer scheme, duty lawyer service. Okay. First of all so people from time to time people will have a legal problem. When a citizen have legal problem, usually what we will do of course he can find the answer from the website or from a textbook or from other book. And also he can seek legal advice from his friend or other people. So please know that some legal advice is free. For example, if you know, so if your friend is a lawyer, or you can consult him, especially for some casual advice. Casual advice is very different from serious advice. Serious advice, usually you have to examine so many documents, you have to do so many things before you can give advice. But for casual advice, so usually it's only question and answer. You ask your friend a question and he answers you very briefly, so it's called casual advice. Most legal service has to be paid. Please note that some legal advice may be free, but most of the legal service has to be paid. Why? Because for the law firm, they have to survive. They have to pay rental to the landlord. They have to pay for the salary of the staff. So you cannot expect all the service are free. Okay? Some service, especially for casual advice, it may be free. But most of the legal service, for example, drafting the document, attending the court, say representing the client all the time, usually those service has to be paid. So you have to pay for the lawyer. Okay. So usually for law firm, we do not receive any subsidy from the government. That is the reason why you have to pay for the legal service. Right. So the legal aid, so the ordinary meaning. It means help with a legal problem. It's a very broad meaning. Okay. So if you ask your friend to give you free legal advice, it's already some kind of legal aid. But more technical meaning is provision of the legal representation determined by the legal department under the legal aid ordinance. Usually when we mention the term legal aid, we are referring to the legal aid service provided by the legal aid department. And also the legal aid department has to follow all the rules in the legal aid ordinance. Operation of the legal aid, altogether we have 3 different schemes. 3個法律援助計劃. Altogether we have 3 different legal aid schemes operated by the legal aid department. So 2 are civil case. The first 2, ordinary legal aid scheme, supplementary legal aid scheme, and so both of them are for civil cases. But we only have 1 legal aid scheme in criminal case. That's the legal aid in criminal cases scheme. So for this photo, you see there's old lady, and so she was called Madam Lo Siu Lan. He appealed to the CFA against the housing authorities link rate, privatization of shopping center and car park. She was living in the public housing. She argued that so if there's a privatization of all the shopping center, so of course the goods will be more expensive. Because so usually the landlord, the rich will charge the tenant very high rental. So everything will be more expensive. Her application was assisted by the legal aid department. Also, you can find so many people they apply for judicial review. So many cases were also assisted by the legal aid department. Application. So if anyone want to apply for legal aid, so he has to make application to the director of legal aid. People that are non-Hong Kong citizen may also apply. Okay, in Hong Kong, we have some people who are refugee, domestic helper from Philippines, Indonesia. They may also apply, even though they are not Hong Kong citizen. The application so in fact is only some kind of formality. Of course, we will not bother to look into the technical details of the application. There are lots of rules or lots of form. So the application will be considered by the Application and Processing Division of the Legal Aid Department in accordance with the provision of the statutory scheme. So you want to know later on, I will show you the website of the Legal Aid Department, so you have some idea about this free legal aid scheme. And also, a very important thing is legal aid is not free. Even though someone can apply for legal aid, even though the application is approved, right? So it does not mean that he does not have to pay. Legal aid is not free, just like public housing. So public housing is not free. The tenant has to pay the rental. Okay? Of course, the rental is much lower than the market rental. Okay? Legal aid is also the case. For legal aid, the applicant have to pay a contribution, sum of money called contribution. Contribution means contribution to the legal cost. 即係對法律費用嘅貢獻。It means that the applicant has to share a part of the legal cost. So we call it contribution towards the cost of the case. Of course, for ordinary legal aid scheme, usually the legal aid department cannot recover all the legal costs they have paid. Just like public housing, the government cannot recover all the costs for the public housing, but at least the government can recover part of the cost. Legal aid department is also the same. Don't expect they can contribute, they can recover all the costs, but at least they can recover part of it. If an application for legal aid is rejected, the applicant can appeal in writing to the registrar of High Court. Registrar is, in fact, he's a judge. No, despite his title, in fact, he's a judge. I think so despite his title, in fact, he's a judge. So I will go through different scheme one by one. The first one is Ordinary Legal Aid Scheme, OLSC. It's for civil proceeding. Okay? It's not for criminal cases. It's only for civil cases. It's available for most type of civil proceeding in CFA, CA, CFI, and also DC. Cases, the typical cases are breach of contract, negligence, matrimonial proceeding. Of course. So matrimonial, I think it's only it means divorce. Okay. I think negligence usually it means accident, traffic accident, and also industrial accident. 交通意外、工傷嗰啲matrimonial usually it means divorce, and also landlord and tenant and employee compensation. These are the typical case of handled by the legal aid department under the ordinary legal aid scheme. There are some exceptions. For example, defamation. In Hong Kong, we don't have too many defamation case in the court. But in fact, defamation in fact is everywhere. So when you are listening to some YouTuber, you can find many defamatory statements. But in Hong Kong, not so many people will take action in defamation because it's very expensive, and also the cost that can be recovered is only a very small amount. So recovery of business loan and most company or partnership dispute claims in the small claim tribunal and also the labor tribunal. For these two tribunal, there will be low legal representation. This is also the reason why legal aid is not available. Because the client he can act for himself. He can do some research, so he can do some reading, and many cases are very straightforward. So there's no need to have any legal representation. And also, legal aid is only available for legal proceeding in Hong Kong. So if someone is involved in legal action outside Hong Kong, for example, in Philippines, in mainland China, so there will be no legal aid. Because legal aid is not available for any legal proceeding outside Hong Kong. Please do that here on page 163. Now please go to the workbook 163. Right? Please go to page 163 of the. Oh, sorry. This one. This one. Activity one. 162. Okay. Sorry, I think there's a typing mistake in the page number. It should be activity one. Question 1 and question 2. Please do these 2 questions before we proceed. Okay, we may go through the 2 questions. So what's the question? What's the answer to question 1? Johnny wants to sue Benny to recover the 1,000 Benny owes him. Can Johnny apply for legal aid? The answer is no. Because it's a small claim tribunal case. It will be included in the scope of the legal aid service. Right? So number 2, William is sued by his colleague in defamation. Can William apply for legal aid? Again, the answer should be no, because it's an exception to the cases covered by the legal aid scheme, ordinary legal aid scheme. Right? So you can now go to the website of the legal aid department. So it's the website of the legal aid department. So we have 3 different legal aid scheme. This one legal aid scheme. So for civil case, so we have ordinary legal aid scheme. So these are the most typical cases. For example, matrimonial usually means divorce. Traffic accident. So industrial accident. These are the major cases of major types of cases in covered by the ordinary legal aid scheme. But of course, so just like public housing, it's not possible for the government to give public housing to every citizen. there must be some say screening process. So of course, in public housing, the main concern is income, okay, or we call it means test. Legal aid is also the same. We have two tests. The first one is called means test. Please know that means does not only mean income, okay? Because some people have very little income, but he has a lot of property, a lot of asset. So in fact, it covers both income and also asset, right? But of course, most people think this term is very redundant. Okay, 入息及資產審查 is so redundant. So many people just call it income tax. But in fact, it covers income and also asset. An applicant for legal aid must satisfy a means test and also a merit test. Also, altogether, we have two tests: means test and also merit test. The other thing, how can you memorize the name of the two tests more easily? Mean test and also merit test. How can you? So when you study law, you have to know that laws, legal study. Sometimes it's only NM very good. So it should be M&M. So some people think that is a very good idea. I just call it M&M, right? I just call it M&M. So it's a usual way for you to memorize the two tests. So for legal aid, you have to go through an M&M test, okay? So maybe in the future, in the examination, bring a pack of NMM to the examination hall so that you can know, you can recall the test for the legal aid. So it should be means and also merit test. The limit. So for the concept is called, later on I will tell you. So it's called financial resource. Now we'll continue the lecture. So now we go to legal aid in criminal cases scheme. So it's the only scheme for criminal cases. So later on, I will also mention the duty lawyer scheme. For magistrate, for legal cases, for court action in magistracy. So it will be covered by the duty lawyer scheme instead of the legal aid in criminal cases scheme. So it's very interesting to look at. So legal aid department does not handle cases in the magistrate. So it will be handled by the duty lawyer service. 當值律師服務later on I will will explain to you the meaning of duty lawyer service. Okay? First of all, for criminal case, it may be more sensitive than civil case. Because for criminal cases, it's some kind of legal right, human right. So all persons facing a criminal charge should have a right to legal assistance under Article 11, Paragraph 2 of the Hong Kong Bill of Rights Ordinance. It means that it's something mandatory. So it covers the scope of the scheme. It covers all types of criminal proceeding in district court, CFI, CA, and also CFA. Please note that legal aid is not available for trial in the magistrate court. It does not mean that there's no legal aid. It only means that it will be covered by another scheme. It's called duty lawyer scheme. The duty lawyer scheme is not administered by the legal aid department. It's administered by the duty lawyer service. Criminal legal aid is subject to the same means test. Means test is just the same as ordinary legal aid scheme. It means that it's just the same. The figure is just the same, 420,000 something. An applicant have to pay contribution towards the legal cost. So the scale is also a sliding scale. The scale is also the same. The only difference is the merit test. Why? Because for for civil case, most of the applicants are plaintiff. For the plaintiff, also usually we have to be very careful in screening the say the request of the plaintiff. Because many people want to sue other people just because they don't have money. If they have money, they will take the legal action very easily. So money is a very important consideration for taking civil cases. Okay? But for criminal cases, usually the applicant he does not want to be involved. No one want to be involved. Because for criminal case, nearly all the applicants are defendant. No one want to be prosecuted. Okay? They're involuntary. So they don't want to be involved. Okay? No one want to be involved. So because for the criminal cases, they are passive because they are prosecuted by the government. Merit test, so we don't have to discourage those applicants. They don't have to be discouraged, right? But for civil case, we have to discourage so people from taking unnecessary legal action, right? So the nature is very different. So for merit test in criminal proceeding is whether the granting of legal aid is desirable in the interest of justice. You will find that the merit test is very different from the one in civil legal aid scheme. So usually in civil legal aid scheme is the test is whether the party, whether the applicant have reasonable ground in defending or taking the legal action. So the merit test is quite different. First of all, so for some important, more serious case like murder, treason, or piracy with violence, those cases are very serious. So there will be, we don't need any merit test. It means that as long as the applicant can pass the means test, he will be entitled to legal aid. Okay, because they are already very serious case. So those serious case, the applicant can get the legal aid without going through the merit test. No need to go through or to pass the merit test for those cases. A murder, everyone knows what's meant by murder. Okay, so it's killing other people. Treason is betraying your country. So we seldom hear someone is guilty of treason. Piracy is also the same. Piracy with violence. Okay? So what's meant by piracy? So this gentleman, he's a pirate, 海盜 okay? But after the death of Chiang Po-chai, I think no one will be prosecuted for piracy. So these two cases, I think you seldom come across this case. So usually in Hong Kong, we only have murder case. For factor relevant to the interest of justice. So what's meant by interest of justice? Okay? So please go to page 171. 171. So these are the factors. For example, so include whether the individual will be likely to lose his liberty or livelihood. Usually it means imprisonment. If the possible punishment is only money or social service order, usually it's not a big deal. So it may not justify legal aid. Or the case involves substantial question of law. Proceeding may involve the tracing, interviewing, or expert cross-examination of witness, or is in the interest of another person that the individual be represented. Okay. Usually it means it must be a more serious case. If the possible penalty is something very minor, usually it will not justify legal aid. We can use a table to compare and contrast the three different schemes. Ordinary legal scheme, supplementary legal aid scheme, both are civil. Only legal aid in criminal cases scheme is for criminal case, right? For means test, so these two, they are just the same. OLAS, and also criminal legal aid. So the means test is also 420,400 financial resources. Of course, supplementary legal aid scheme, they have a much higher limit. So it's 2.1 million. Okay. So for merit test, both civil case legal scheme, they are using reasonable ground as the test for the merit test. So for criminal legal aid scheme, is whether it's desirable in the interest of justice. Right? So this is a very good summary of the three different schemes. You cannot find this table in the workbook. Do you know why? Because this table is prepared by me. Okay. It's very useful. I think many students think that this table is very useful. So by this table, you can compare and contrast the three different schemes. So you have a very good idea, very clear idea, very clear concept about what this three scheme will cover. But as we have mentioned before, legal aid is so the criminal legal aid scheme is not applicable to cases in the magistrate. Legal aid is not available for proceeding in magistrate, but advice, assistance, and also representation are available under other scheme. So it's called the duty lawyer service. Please note that the duty lawyer service is a collective term for four different schemes. This duty lawyer service, in fact, is some kind of commission. So it's very similar to say the Consumer Council or the say Equal Opportunity Commission. No, the nature is very different. This organization, in fact, is funded by the government. So all the money come from the government because they only have very small income. So of course the applicant will pay fee, but the fee is very minimal. Okay. So it means that of course you can expect the service cannot cover the cost. So where does the money come from? The money comes from the government. Okay. The government has provided the funding so to this service. Right? So at the very beginning, they are called duty lawyer scheme. It has the longest history. 當值律師嘅話 duty lawyer scheme So now then they have another scheme. So collectively, so it's called duty lawyer service. In fact, it's some kind of commission. So it's a public organization, and the money is funded by the government. Okay? You can find from the website. So you can go to the website. So it's the website of the duty lawyer service. Okay? So don't be misled by the name. So of course they will provide service. But in fact, it's some kind of commission. 好似某啲消費者委員會咁嗰啲之類嘅組織something like the Consumer Council. So from the website, you can find you have 4 different schemes. Duty lawyer scheme, free legal advice scheme, tail law scheme, and also legal assistance scheme for non-refoulement claimant. 呢個酷刑傾請，以前叫酷刑聲請，而家叫免遣返聲請。I think they have changed the name. So these are the 4 schemes operated by the service. Right? So you may go to the annual annual report. For the administration, so you have the council. Council membership is Appendix A, A1. Okay. So and also staff committee. So staff. Go to staff. Altogether, how many staff they have? So in this year, the number of staff stand at 128, including 5 officers specifically assigned for the care or protection scheme. Altogether, they have 128 staff. Some of them are called court liaison officer, 法庭聯絡主任。In the magistrate, so in Hong Kong we have 9 magistrate. Each magistrate there are some court liaison officer. Right? The duty of the court liaison officer is to liaise. So the applicant and also the lawyer on duty. Okay, so they have the list of lawyer who are on duty. So for the court liaison officer, he will contact those people to arrange legal representation for the applicant. And also for the finance, can you guess how much money they have spent? So it's from in the year 2018 to 2019. The total amount was 249 million. 2億4,900萬. It's increasing. I can tell you. So the trend is increasing, but no, it's there's a slight downward adjustment in the year 2018 to 2019. I recall several years before it was only 100 million. Now it's 249 million. You can go to appendix. So it's the council. You can see the council. All the council members are some are nominated by the 2 law society. So some are nominated by the Bar Association and also the Law Society. Okay? 各自係兩個律師會係提名一啲人做嘅。Okay? And also we have some lay member. Lay member means those people who are not lawyer. They are called lay member. So we have 3 lay member. So altogether, so we have 10 members from the 2 different law society, 2 different society. So Bar Association, I think we have 4 member. Law Society also 4 member. Okay. And also we have the administrator. Administrator in fact is the chief executive. 呢個就係其實真係相當於係嗰個行政總裁。But the title is only administrator. In fact, she's the head of the duty lawyer service. You can find a lot of useful information. So for the 4 different schemes, okay, you can go through. They also have the means and merit test, but it's a little bit different from the means and merit test used in the legal aid scheme administered by the legal aid department. These are the 4 different schemes. So this one is the most important one. It's the earliest one. So the main duty is to provide legal representation in criminal cases in magistrate court. So and also the free legal advice scheme is only for some casual advice. Tell law so it's provision of legal information through the telephone. Law is also through the internet. For this one, it's only provision of information, no consultation service. Okay, you can only go to the website and find some useful information. But no one will answer your question for this scheme. This one, so there will be legal consultation. So the lawyer will answer the question, but limit to I think is half an hour consultation. Convention against torture scheme. So it's for the refugee. Duty law scheme cover all proceeding in magistrate court with the exception of criminal proceeding, hawking offences, traffic offences, and other regulatory offences. It can also cover all proceeding in juvenile court. You can find a list in the website of the duty law service. Legal representation under the duty law scheme is free on the first occasion. For subsequent, so first occasion usually is to plead guilty or not. For the first occasion, it's only for pleading guilty. Right? So if the defendant plead guilty, usually there's no need to have further, legal representation. So it's free on the first occasion. For subsequent appearance, the defendant is subject to the means test. A mean test is quite simple when compared with the mean test used by the legal aid department. So no regard is paid to disposable capital. It means that they will not consider your capital, even though you have you own 10 apartments. So it will not be counted. So it's only calculated solely on the basis of a defendant's gross annual income. So it's I think the latest figure is 210,000 something. So if you divide it by 12, so the figure is around I think 118,000 something. 即係每月1,800左右。Okay? So the income, the monthly income, you divide this figure by 12, so it would be around 118,000 something. So you just want to give you a rough idea of how much income the applicant can earn in order before he can be eligible to legal aid. And also there's low deduction for rental. And also low allowance. Okay, so just very simple. Just look at the gross annual income of the applicant or defendant. Duty law, so everyone represented has to pay a fixed handling charge. It's only $770. So of course it's a very small amount. Usually the lawyer will charge several thousand for 1 day trial in the magistrate. So of course you can expect this amount can never cover the cost. So it means that the legal aid service must incur a lot of loss every year. Of course, all the money from the government, they cannot cover the cost. No more handling charge. For other services, usually they're free of charge. Right? So it means that, and also we have the staff call, rental, etc. So you can expect they can never cover the cost. And also it's very funny. So do you know the location of the duty lawyer service? Do you know where is the office? Contact us. Now they move to Harcourt House. It's much better now. I think it's also a Grade A office. Gloucester Road. Adventure. In the past, I think they were in Landmark. I don't know. I'm not sure. I recall that several years before they were in Landmark. Now they moved to Gloucester Road, at least in It should be a quite quite expensive office tower. So free legal advice scheme. So I think this one is so it's only some kind of initial legal advice to member of the public to seek clarification of the legal position in situation of genuine concern. For example, if a woman want to divorce with his husband, of course he want to seek some legal advice. The lawyer will give her some legal advice on divorce, what will get, and what's the probable procedure, etc. Applicant must first approach a referral agents. Usually it's a local social welfare organization to make an appointment at one of the scheme's line legal advice center. For those legal advice center, in fact, they are simply the office, the district office 即係用借啲政務處嘅地方民政處sorry so they just use the office of the Home Affairs Department This generally open for one evening a week so it's not the office owned or leased by the duty lawyer scheme so it's only the district office of the government right? And staff by volunteer lawyer who may spend 20 to 30 minutes offering general legal advice on each case. The lawyer will not draft any legal document. He only give a brief advice to the applicant. There's no mean test or charges. So low screening and also low charges. The applicant does not have to pay any money, but the free legal advice is limited to one single 20 to 30-minute interview. It's not possible to seek any follow-up advice or formal legal representation through the scheme. The lawyer will not prepare any document. He will not represent so the applicant in any case. And also the applicant usually he is not allowed to contact that lawyer in the future. Okay? And also the lawyer cannot provide any service to that applicant in the future. We want to avoid soliciting of business 防止佢哋用呢個方法去撈生意So no, we have to prevent the lawyer from soliciting business through the legal advice scheme. The scheme is most often seek advice on commercial and property dispute like tenancy or also matrimonial cases. Usually it means divorce. However, it cannot be used to seek legal advice on foreign law, including law in mainland China, or dispute involving company. I think for law in mainland China, you better consult the FTU, Federation of Trade Union, 工聯會, okay? I think FTU would be more competent in providing advice relating to mainland China. Tell law, so now in the past they provide information through the telephone. It means you dial the telephone number and then you press the appropriate figure number, and you can listen to some information through the telephone. Because they also provide information through the internet. I provide legal information on a wide range of social legal topics through the telephone and on its website. We can click to the say this one. So tell law. So you have 80 topics divided into 8 groups. Family law, of course, usually means divorce, landlord tenant, criminal, different criminal offences, employment law, commercial banking, administration, environmental law, general legal information. So you can find a lot of useful information. Okay? But no one will answer your question. So you can only get some information, but no one will answer your question. The last one, I think, very sorry. I think they have already changed the name. I think I will prepare. I forget. So when I check the say the website, I forgot to check the name. I don't know whether they have already changed the name of the scheme. Previously, it was called Convention Against Torture Scheme. 酷刑聲請計劃 okay? So it means some applicant was tortured by the own government. So they apply for assistance under the scheme. I think they have already changed the name. I'm very sorry about that. I think they have already changed the name to Legal Assistance Scheme for Law Enforcement Claimant. The nature may be more or less the same, but I think they have changed the name. I'm very sorry about that. The scheme provides legal assistance free of charge to torture claimant without any means test. So although applicant must make a statutory declaration, they lack sufficient means to pay for their own legal representation. But of course, it is a formality. Most of the applicant can make this statutory declaration very easily. And also apart from the legal aid department and also the duty lawyer service, from time to time you can find lots of free legal advice given by barrister. For this one, please is the bar free legal services scheme. The scheme is operated by the bar association. Is some kind of free legal advice given by barrister in private practice. And also we can find many the legal political party, district board member, legislative council. For those politicians, they also provide law talk and also legal advice. Okay? But usually the assistant is only legal advice. Okay? Because it won't be so time consuming. Legal representation will be more expensive. Legal representation. Legal representation means to represent someone in the court, to draft legal document for him, to prepare letter, legal documentation like statement of claim, defense, etc. Usually it will be much more time consuming. But for law talk, legal advice, they will not be so time consuming. So it will be much more available. So many organizations can provide, can organize law talk. They just invite a guest speaker to deliver the talk. And for legal advice, they can ask some volunteer, a lawyer to prepare some casual legal advice to the citizen or resident. But for legal representation, you cannot find any aided legal representation except the legal aid department and also the duty lawyer service. Only these two can provide free or assisted legal representation. 就係俾一啲法律意見係好容易嘅，就係如果真係做埋法律服務係好困難嘅。So these are the reference. You can always go to this website, like the website of the legal department, website of the Community Legal Information Center, and also duty lawyer scheme, resource center for unrepresented litigants. The court also provides some kind of service, but it's only information. If you want to sue someone in the small claim tribunal, usually the clerk can assist you for procedural matter, but they will not give you any legal advice. So they will only give you some advice on procedure, but they won't give you any legal advice. Okay? To test your knowledge, please go to page 172 of the manual. These are some question. So you please do this question to see whether you can understand all the law relating to the three different legal schemes. So please do this question one first. Question one, Wong is a hawker. He regularly blocked the entrance to Chen's premises. Chen has never given permission to do so. Okay? And Chen has commenced proceeding for an injunction to order Wong to stop blocking the access. For the purpose of this access, you may assume that Chen has good legal ground for taking the proceeding. Of course, it's very reasonable for Chen to take this legal proceeding because Wong, he's a hawker. He had no reasonable ground to block the entrance. Wong's financial resources amount to 50,000 only. See whether Wong will be eligible to legal aid. Okay. Please answer question one first. And so for your answer, don't just say yes or no. So you have to pass the two tests And also you have to consider whether the case is covered by any legal aid scheme. Okay? First of all, you have to consider whether it falls within any legal aid scheme. If the answer is yes, then you proceed to M&M, so the means test and also the merit test. Okay, so for question 1, do you think he can get legal aid? First of all, so is it within, does it fall within the scope of the any legal aid scheme? Is this civil case or criminal case? Of course, it's a civil case. It fall within the ordinary legal aid scheme. So there's no problem. So how about means test? So do you think Wong can pass the means test? The answer is yes. He can pass the means test. How about merit test? Do you think Wong can pass the merit test? Okay, thank you. So I think the answer should be low because there's no reasonable ground to defend. He has no reasonable excuse. Because he is only a hawker, he blocked the access. So it's a very unreasonable behavior. It seems that Wong has no reasonable ground to defend the case. So he cannot pass the merit test. The legal aid department will only be wasting money on defending him. Right? Now we go to question 2. Lee was arrested by police for shopkeeping. He has been charged with theft. Contrary to Section 9 of the Theft Ordinance, he has been released on bail. Her case will be heard in Mac Court next week. Her financial resources amount to $535,000, and she has a gross annual income of $300,000. Do you think he will be eligible to legal aid? Question 2. Please do question 2. No. First of all, the scope of the scheme. Do you think this case fall within any legal aid scheme? criminal legal scheme, you see? It should not be the legal scheme because it will be heard in the magistrate court. So it will be covered by which scheme? It should be covered by the duty lawyer scheme. So it should be covered by the duty lawyer scheme. Financial resources irrelevant. For duty lawyer scheme, they do not consider the assets, so they do not use the concept of financial resources. So what concept they use? They use the gross annual income. So 300,000 has already exceeded the upper limit. The upper limit is only 210,000 something。咁我哋個最高係21萬嘅，咁30萬就過咗啦。譬如300,000 has already exceeded the upper limit of gross annual income. Say used by the duty lawyer service. So for question 2, the answer should be low. Okay, so Lee would not be eligible. And also, over here, would your answer to question 2 be different if Lee's financial resources amounted to 100,000 and she has a gross annual income of 120,000 and Lee was charged before the district court instead of the Met court? How about question 3? So if the case was charged before the district court, would it be governed by the duty lawyer scheme or any legal aid scheme? Legal aid, so the answer should be legal aid scheme. If the case was charged before the district court, it will be covered by the criminal legal aid scheme. So we'll use the concept of financial resources. Gross annual income will be irrelevant. If the case is to be heard in district court, so it will be covered by the criminal law cases scheme, operated, administered by the legal aid department. So the concept of financial resources will be used. If the financial resources is only 100,000, of course, he can pass the means test. So usually he can pass the merit test. FAP case, usually he can pass the merit test. So it's most likely he will be eligible to legal aid. Number 4, question 4. Tong suffered serious injury following an operation at Fong Ling Hospital. She wanted to sue the hospital. Her financial resources amounted to 350,000. Do you think Tong will be eligible to legal aid? Which legal aid scheme will cover this case? Very good. So it should be the supplementary legal aid scheme. So most likely it will be covered by the supplementary legal aid scheme. Okay. Of course, you can use it because it's a professional negligence. So it's not traffic accident or industrial accident. So it may not be covered by the ordinary legal aid scheme, even though he can pass the mean test. So 350,000 is still below the upper limit of the say ordinary legal scheme. But this kind of case usually is covered by a supplementary legal aid scheme because it's professional negligence or negligence. So for this case, so I think she can pass both the merit test and also mean test. Because the eligibility for financial resources, the upper limit is 1.2 million. Number 5. Do you think Lai will be eligible to legal aid? You mean the same? But can you find the difference? 1.8 million. 1.8 million. Do you think he will? Do you think Lai will still be eligible to 呢個 Yes or no? Means test do you think you can pass a means test? Yeah, I think the answer is yes. Because even though her financial resources is 1.8 million, so I think now it's 2.1 million. So he can still pass the means test. Okay? Despite the fact that financial resources is already 1.8 million. Because for the supplementary degree scheme, the financial resources upper limit is 2.1 million. So he can still pass the means test. So for each question, you have to find the relevant degree scheme, criteria to determine whether the degree will be granted. So it should be the two tests, a means test and also merit test. Okay. And now we go to another question. Another one also is the question on page 176. Question one. Henry John agreed to sell and deliver 10,000 mobile phone to Sylvia Leung. Henry delivered 5,000, but told Sylvia she could not deliver the rest. Sylvia obtained the remaining 5,000 phones from another supplier at a higher price. She wishes to sue Henry. Her financial resources amount to 250,000. Answer the following question. What statutory legal aid scheme apply to this fact? B, is legal aid likely to be granted? Let's see, if so, what's the maximum sum Sylvia may have to contribute to the cost? For C, you don't have to answer because you can only find the answer in the website of the legal aid department. For C, no need to answer. Right? Please find out the answer. So just answer A and also B. Okay, so for question A, what should be the scheme? So which is applicable to this fact? Which one? It should be ordinary legal scheme. Okay, so for question A, I think the answer should be ordinary legal scheme. B, is legal A likely to be granted? So we have to apply. So we have to consider. The two tests, means test. Do you think Sylvia can pass the means test? And also merit test. Do you think she can pass the means test and also merit test? You think no? Chang come fire, you say no, why? I think it should be yes for both tests. So means test is only 250,000. For merit test, we also have a reasonable ground for taking the action because Henry failed to deliver the 10,000 mobile phone to Sylvia. Right? So it would amount to breach of contract. And also she incurred loss because she had to buy the remaining 5,000 phone from another supplier at a higher price. So the price difference will be the loss suffered by Sylvia. So what's the maximum sum? Sylvia may have to contribute to the cost of legal aid. So if the financial resources is 250,000, so we have to go to the website of the legal aid department. So this is the contribution. 250,000 if fall within this band. So the relevant percentage should be 10%. Okay, so it should be say 25,000. Okay? So the contribution should be 250,000 times 10%, which is 25,000. 25萬乘10% 就2萬5. Okay? So it's the contribution to be made by Sylvia. So she had to pay 25,000 towards contribution towards the legal costs. Now we go to the last question, Walter's question. Water law is new territory taxi driver. He was arrested by the police during a peaceful demonstration on the public pavement outside the government offices in Lower Albert Road. He was arrested by the police when he ignored police warning to move on. He was charged with obstruction of a public place. He was convicted by magistrate and wishes to appeal against the decision. Walter's financial resources amount to 150,000. Answer the following question. First of all, which court will hear the appeal? So people will decide whether Walter should be granted legal aid. What criteria will be used? For A, which court will hear the appeal? So I think most students can give the right answer. So it should be the CFI, Court of First Instance. Who will decide whether Walter should be granted legal aid? Who will make the decision? Director of legal area background. So it should be the director of legal area. Of course, the job is done by the legal aid officer or legal aid counsel. People that usually I think they use the title of legal aid counsel. In fact, the legal aid counsel is a lawyer, maybe a solicitor or barrister. But he will not handle the case by himself. So usually they will beef out the case to law firm. Okay? See, what criteria will be used in assessing, in deciding whether water should be granted legal aid. So, what criteria will be used? So, it's the M&M. Okay, people. It should be the M&M means test and also merit test. So you can see that for the means test, I think he can pass because he only have the financial resources amount to 150,000, which is well below the upper limit, which is 420,000 something. And also merit test, I think quite likely. So of course, no, you have to assess the evidence to see whether it's a reasonable ground to appeal to a higher court. Number three, question three, legal aid is fee. Do you think do you agree with this statement? Legal aid is free. Yes or no? Most likely it's no. Unless subject to an exception. Subject to an exception, your financial resources fall within this band. Okay, if your financial resources does not exceed 52,550. So the answer will be yes. Say you are very poor. Your financial resources is only within this band. So you don't have to contribute. Okay. But if it's a duty lawyer scheme, so you still have to pay the $570. So for the duty lawyer scheme, even though you are very poor, you still have to pay $570 as handling charge. So even though the fee is very low, it's not free. Okay. And now please do the revision question. So it's the end of the lecture. Please go to the say no. This one. Please do the revision question before we leave. Okay, I will go through the answer very briefly. So question one, standard legal aid provided by the legal aid department includes so legal aid in criminal cases, legal aid in civil cases, and also supplementary legal aid scheme. These are the three different legal aid schemes administered by the legal aid department. So number two, an applicant for legal aid must satisfy both the means test and also merit test. So we call it M and M. So number three, duty lawyer service is legal representation in criminal cases in magistrate court. So of course it's a very special arrangement. I think the government can save money by using the legal duty lawyer service instead of the legal aid legal aid department. Because for the duty lawyer service, mainly they will use the duty lawyer. So the fee will be lower. So then that charged by the legal aid scheme. Number four, legal aid is not free. Applicant are required to pay a contribution. The term is called contribution towards the cost of the case. It means that they have to pay a certain percentage of the financial resources. But please note that the contribution is in proportion to the financial resources instead of the legal costs. Bar free legal advice service scheme provide free legal advice given by a barrister in private practice. So true and false. Number one, true or false? Please give your answer through the chat room. True or false? True. It should be false. Non-Hong Kong citizens, they can still apply for legal aid, including domestic helper like Filipino maid or Indonesian maid or refugee. They can still apply for legal aid. No need to be a Hong Kong citizen. Number two, criminal legal aid is subject to the same means test as ordinary legal aid. True or false? For question two. It should be true. Okay. The mean test is just the same for criminal legal aid scheme and also ordinary legal aid scheme. Number two, an application for legal aid is rejected. The applicant cannot appeal. Cannot. True or false? It should be false. It means that he can appeal to the court. MC, which type of civil proceeding are covered by the ordinary legal aid scheme? Civil proceeding. A, B, C, and D. Very good. It should be A. So number one and number two are district court and also court of appeal. Because Mag court is not civil case. Please note magistrate court, despite the fact that it's only handling some petty cases, it's a criminal court. It's not civil court. Many people do not know. Littering, spitting, they are still criminal. Okay. Number two, which of the following statement about supplementary legal aid scheme is correct? A, B, C, D. Among A, B, C, and D, which one are correct? Only C? It's incorrect. Sorry, it's incorrect. Only C. Only C is incorrect. Both all A, B, and D are correct. Because it's for the sandwich cars. So who cannot afford legal costs, but who are not eligible to legal aid under the ordinary legal aid scheme. Higher financial eligibility limit. So it's 2.1 million now. Self-financing. So basically, it can cover the cost. Sometimes it may have very small, say, they will suffer loss, but only a very small amount. But usually the supplementary legal aid scheme can be self-financing. Usually. Which one is not covered by ordinary legal aid scheme? A, B, C, and D. It should be B. Very good. It should be B. Defamation. Which one does not require merit test? Question 4. It should be A, B. That's right. It should be A, B, and also C. Okay. Both all A, B, C do not require merit test. Right. Only D will require merit test. Right. Okay. Thank you very much for attending the lecture. Okay. So we can also so we still have some time. We can still visit. For example, this one. So you can also find lots of information from the website of Community Legal Information Center. So this one, I think they will use information is more or less the same, right? But sometimes they may not update the figure. The figure may be outdated. So I think it's more or less the same. Okay, I think this part is not so too useful because I think because the legal aid department has provided a lot of information. We can also find so now we have the news and also I think they also have the report. So you want to know more, you may visit. You may read the LAD departmental report. There are so many different reports. Right? Also, you can find we have 2 clips. Okay. Altogether, we have 2 clips about legal aid, but it's too long. So we do not play the clips. I don't know whether why Adobe Flash Players is blocked. If you go to this website, you can find we have 2 clips. So it's about legal aid service and also the criminal legal aid scheme. For the statistics, you can find. So there's a big difference. Civil case has a much bigger figure. The reason is for the cases in the Met Court is covered by the duty lawyer scheme. So it's the reason why the number of criminal cases is much smaller than the number of civil cases. I think the legal aid department is under very serious criticism by the pro-government people. So now they have tightened the criteria for for the merit test, especially for the judicial review against the government. Right? And now I think most people find very difficult to get legal aid if they are going to sue the government. Right? In the past, so many people could get the legal aid, including the king of judicial review in Changchao, Mr. Cont, okay, and also Mr. Leung Kok Hong. Okay, many years ago, they could apply for legal aid to sue the government in a judicial review case. I think now the government is quite reluctant to grant legal aid to those people because they are under the very heavy pressure from pro-government people or pro-Beijing people. For civil cases by different types. So it's mainly the biggest one should be personal injury. Personal injury will include traffic accident and also industrial accident. So in litigation they are the biggest number 我哋民事最大咧就係呢兩種交通意外工傷賠償traffic accident and also industrial accident so usually they are collectively they are called PI PI case personal injury usually there will be personal injury for those accidents and then matrimonial matrimonial of course is about divorce wage claim is only a very small amount the number is very small by different level court so the lower court, district court, I think is still the biggest one so higher court, I think is the number is very more legal costs you can find the legal costs expanded so the yellow one is the damages recovered. Damages mean compensation收翻幾多賠償翻嚟嘅cost recover is the blue one so it's the legal aid cost it's this one assignment so I think from time to time there are lots of dispute about assignment to lawyer or to law firm this one is barrister, this one is solicitor so of course more experienced people they can get more job in the past, I think when I was working in law firm, only a few law firms were willing to take up legal aid cases because the income was very small. But nowadays, because the economy is so bad, competition is quite keen, and so more and more lawyers are willing to take up legal aid cases. So from time to time, they will have a lot of dispute. Some people will complain they cannot get any case, and some people can get a lot of cases because they have good relationship with the staff of the legal aid department. So you can only you can find more information from the report. For example, the structure of the legal aid department. You can go to those reports. You can find more information. These are the report of the legal aid department. You go to organization, administration. This one is the structure. So this gentleman is the head, the director of legal aid. So these are the different department or unit in the legal aid department. So she's the assistant director. I don't know whether okay, that's all. So if you want to know more about the legal aid department, you can go to the report of the legal aid department. You can find more information. Thank you very much for coming. So it will be the second last question. Second last lesson. Okay. Next week we will have the say the last lesson. So assignment, I think we will do it in the next lesson. Okay. So student always ask me about the assignment. If you have any question, you may just say give a message to me. So now開威may I know if a law firm talk about legal aid case and if one case will its professional fee be paid from another party or should it first be paid by legal aid? Professional fee, I think Usually, it will be paid by the legal aid department. You mean the legal cost? The legal cost, I think, it will be paid by the legal aid department. Okay. Just like a lawyer. So you will retain a lawyer. If you win the case, you have to settle the bill first. Of course, it's up to the law firm to decide. Some law firm, they are more considerate. They will wait until they can get the damages. And also they can deduct the damages. They can deduct the fee from the damages. So I think at the end of the day, it depends on how fast they can get the compensation from the defendant. If the defendant is an insurance company, usually it will be quite early for them to get the compensation. What's the hourly rate for hiring a newly qualified lawyer? I think it's only $2,000 to $3,000 per hour. Of course, you can say negotiate with him. Okay, thank you very much. Thank you very much for attending the lecture and all your participation.